Hey guys, my name is Shashwat and I'm a lead intern at LEXIS and Company. In this video I'm going to talk about the anti-ragging laws in India and the measures to be taken by the university. So the anti-ragging laws, so first of all, ragging, as we all know, is social interaction between the seniors and juniors in schools and colleges. An interaction which can take very brutal, inhuman social form at sometimes. In this, even some of the ugly and some of the high reputed colleges, very ugly and very terrible history of ragging occurs. Looking at this, anti-ragging laws are now very much necessary. Some states in India have their own legislation on ragging. Some states do not have their own legislations on ragging, and therefore the ragging laws in these states are according with the central legislation on ragging. The central legislation check the practice of ragging in India are firstly the Indian Penal Code, then UGC regulations on fundamental of ragging in higher education institutions 2009, and thirdly the other institute specific regulations. The UGC, firstly the Indian Penal Code, it consists of Article 294, that is obscene acts and songs, then Article 3, Section 294, then Section 323, punishment for voluntary causing hurt, Section 324, voluntary causing hurt by dangerous weapon or means, Section 325, punishment for voluntary causing grievous hurt, Section 326, voluntary causing grievous hurt by dangerous weapon, Section 339, wrongful restraint, then Section 340, wrongful confinement, Section 341, punishment for wrongful restraint, Section 342, punishment for wrongful confinement, and then Section 506, that is punishment for culpable homicide not amounting to murder. Under UGC regulations, these regulations were passed by the University Grant Commission in the year 2009 to curb menace of ragging in the universities of India. In this, the Regulation 6 talks about the measures of the prevention of ragging at the institution level. In this, every fresh student admitted to the institution shall be given a printed leaflet detailing to whom he or she has to turn for help and guidance for various purposes, including addresses and telephone numbers, so that as to enable the student to contact the concerned person anytime. Then Regulation 6.3 says that every institution shall constitute a committee to be known as anti-ragging committee, to be nominated and headed by the head of the constitution, and consisting of representatives of civil and police administration, local media, non-government organizations involved in youth activities, and etc. Then Regulation 7 lays down that on receipt of any information concerning any report of incident of ragging, the head of institution shall immediately determine if a case under the penal laws is made out, and if so, either on his own or through a member of the anti-ragging committee, proceed to file the FIR within 24 hours of receipt of such information. Then also the Regulation 9 in UGC regulations lays down that the anti-ragging committee of the institution shall take place an appropriate decision in regard to the punishment or otherwise, depending on the facts of each incident of ragging and nature and gravity of the incident of ragging established in the recommendations of the anti-ragging squad. Apart from IPC and UGC, there are other government bodies which have their own laws on ragging in their respective acts. For example, the All India Council for Technical Education and the Medical Council for India have made their own regulations under their respective acts. The All India Council for Technical education of ragging, education regulation 2009 and the section 23 and section 10 of the AICT Act 1987 have mentioned. Similarly, in the Medical Council of India Regulation 2009 under section 33 of the Indian Medical Council Act 1956, they have the regulations against the anti-ragging, against ragging.